Mr. Prowler,
Yeah.
we got you. And
all right. Good morning.
If you move back a little bit,
I was trying to figure it out with the lights and the.
Come on, brother.
Yeah. Let's see if it's the back.
There you go.
Yeah. Okay.
Good morning, sir. Good morning.
Good
Welcome.
morning.
Thank you for joining us, and it's yours.
All right. Well, first, I want to just thank you for allowing me to address you all this morning, and I want to congratulate Monique Anderson Walker, former council person, and I know the future looks great for her. And I'm excited. I'm excited for Maryland. So good, wishing you the best of luck. I sit here as deputy state's attorney. I can't make any political endorsements like you guys, but you're smiling, so we're happy. Yeah. So you want it out of the horse's mouth. Well, I work for the state's attorney, but I can give you the best that I can. So let's start out at the beginning with the brief historical context that we're still experiencing the impacts of COVID-19. And we have, with the courthouse closures in 20 and 21, we experienced a backlog of 1,800 cases, not 18, 1,800 cases that have been in the queue. The problem is right now with our social distancing requirements for the courthouse, we have anywhere between 12 and 14 courtrooms. We can only hold 3 trials a day. And it takes 3 courtrooms to pick 1 jury for 1 trial. So what's happening is that we have to prioritize. We work with the defense attorneys, both the public defender and the private bar and the court. First, we prioritize homicide cases, right? And in the majority of those cases, the defendants are held pre-trial. Then there's the right behind that, when the defendants are held, the sexual assault cases. Those are our highest priority. And then we go from the third level is defendants that are held in jail. Generally, it could be armed robbery, carjacking, things of that nature. And so once you reach the priority, we might have on any given Monday, we could have 20 to 25 cases scheduled, knowing that only 3, a possibility of 3 could go forward. So we've been flat at that 1,800 number because every time we get 3 to go to trial and maybe 5 or 6 might plead, sadly, more arrests are going to come in, the very next day. So we've been, and that's kind of impacted, how we've had to do business. One of the things that, when the state's attorney prior to COVID, when she took office, she was very big on diversion programs. And I want to make sure I can define that so everybody knows what I mean. Diversion programs are that period after arrest and before a defendant is sentenced and convicted. Without diversion programs, you have to go through the whole process and end up with the conviction on your record. With the diversion programs, it's when we can come in, offer training, offer restorative opportunities, offer educational programs prior to the conviction, but we can get accountability, but we can also have the alleged accused person avoid the conviction. Now, Ms. Braveboy, I'm sure they anticipate COVID, right? But that was part of her belief. And we run about 4 or 5 diversion programs out of the state's attorney's office. Well, it just so happens that it benefits us because now we're able to offer those programs, and they're all to nonviolent offenders, with the exception of our domestic violence diversion program, where that's only second-degree assault, misdemeanor level violence, and it has to be with the consent of both parties, right? So you're not going to get diversion if it was a husband and a wife. If your wife doesn't want you in the program, then you don't get in the program. But so luckily we had these programs in place and we're operating them. So our problem with our diversion programs is that quite frankly, we're just running out of space. We just don't have the resources to take on all the eligible persons. For defendants who are charged and not incarcerated, we have people that were charged as far back as 2019 that still haven't been able to get a court date yet. And so what happens is we're offering the diversion programs. And look, it's a human process. They turn it down. And then when their trial date is there, the judge walks on the bench and they're looking at the 5 years. They're like, we'll take the diversion program, right? So the trial date kind of pushes that. And that's when we came back to operations and having trials of any sort, we saw our diversion numbers increase. A couple of things we have going on. I know you've heard us talk about it before. In 2021, we saw the uptick from 2020 in carjacking cases. So the state attorney started a carjacking task force, which she asked me to chair. We meet monthly as a committee of a whole, and then our committees meet independently monthly. And one of the things that, obviously deterrence was a big factor with our police, but we realized we couldn't arrest our way out of it. So we have different programs. We have a resource committee. With that resource committee is with elected officials, but also some private businesses, the car dealerships and the insurance companies. They have a financial interest, right? And so we work with them. We also had an educational component where we work through schools and park and planning just to provide alternate activities. We noticed that, sadly, a large number of our arrests for carjacking cases were in a particular demographic. It was our youthful offenders. Juvenile offenders were committing carjackings. And a lot of it has to do with the technology. If you have a key fob now, it's kind of hard to just steal the car like people used to do. Years ago, you would hear about stolen vehicles. It's kind of hard to actually take the car without the key fob. So that means they have to have the in-person interaction between the assailant and the victim to get the key and the key fob. And it's obviously sometimes there's weapons involved. And what's so sad is that it's a very violent crime. It's very aggressive. And some of these young people are only taking the cars for an hour or two. It's not uncommon for a car to be stolen and switch hands between the Prince George's District of Columbia border 2 or 3 times. So these kids share cars like we used to share bikes. And we worked hard. When it first started out, you could commit a carjacking offense in Maryland, drive into DC, the car is reported stolen. But once arrested in DC, that was only an unauthorized use because the theft did not occur in DC. So what was going on is that they weren't holding the youth and they were just arresting him that night, getting a citation in DC and being released. So our chief of our youth justice unit, Mike Glenn, and the state's attorney, they worked really hard with the attorney general's office. In DC, they have 2 prosecutors. They have the U.S. attorney and they have the attorney general's office. The AG's office handles the juvenile docket. They worked hard with the AG's office to ensure that those persons are now being held and giving us a certain period of hours to our sheriffs we can reissue writs and go pick them up and bring them back. So that's something that's really helped us. Inside of the carjacking committee, we realized that a lot of these offenses were done with guns, and then we noticed our gun cases were skyrocketing. So we started a separate gun committee, and I chair that subcommittee, and we meet with county officers, municipal, our firearms examination unit, and our state troopers to really make sure at least we know the data and try to get our arms around these gun offenses, and really to make sure that we're doing everything we can to prepare for trial and have all the discovery. A lot of these cases are traffic stops are the #1 generator of illegal handguns in the county. And a lot of these traffic stops are recorded via dash cam and body cam. And to be quite candid, when I was a young prosecutor, a traffic stop, you just got a 2-page report. And the officer said this, I pulled him over, smelled marijuana, searched the car, made the arrest. And that's all you had to do. Well, and you give that to the defense attorney, and you've met your burden. Well, now everything's recorded. Well, you could be out there for 45 minutes to an hour on a traffic stop, and all of it is recorded. we've had hundreds, like 300, 400, 500 gun arrests seized over the year. So we're looking at a lot of video that has to be analyzed. We have made requests for requisite personnel because we have a duty to review it, to review the evidence, and make sure that, you know, all their arrests and the interaction between the police and citizens comply with our area of law, with the law, right? We want to make sure that our residents are being treated fairly. Another thing on my notes, I sadly have to mention homicides were up. A few weeks ago, we went over 100 homicides. We were 93 for the year last year. So we're probably about 112, 113 right now. So we're going the wrong direction with that. I believe that's tethered to the gun violence. So we're being aggressive on our gun cases and, you know, trying to fight that area. So, and then I guess the last thing I want to mention, we stay in the news. We were in the news last week along with Baltimore City. You know, since Ms. Braveboy was here, we did generate a do not call list for officers. And this is when we learn that an officer's conduct, whether it be for integrity, testifying falsely under oath, or racial bias, if they're determined to be found guilty of one of those offenses by a trial board or by convincing evidence, the state's attorney has made a determination she will no longer sponsor them as witnesses. So we've had that list for a while, and for months we have been sharing that with the police, and they've had the opportunity. And, you know, we did have a thing with due process. If an officer wanted to contest that he or she did not belong on the list, they were given the opportunity. And we did take a second look at some of these officers, and we did current and retired officers because, you know, we felt it necessary to just make sure that anyone convicted in Prince George's County, it was based purely because they were found guilty, but based on credible evidence that we could stand behind. And so that was released in the news. And part of it was like working for Ms. Braveboy, we set the standards since she's been here. And for instance, we called the Attorney General's office. There were lists, there were requests for our list, and we called the Attorney General's office, and they gave an opinion that you don't have to give it out. And Ms. Braveboy was like, that can't be right. We know where the law is. And then finally, the highest court, the Court of Appeals, actually ruled with us that yes, you do have to disclose it. So it wasn't anything like, well, we were trying to demean the police or anything like that. We waited. We did not agree with the Attorney General. We made that known. And then the Court of Appeals ruled with us that citizens have the right to know basically what's going on with their police department. So Prince George's and Baltimore City released their do not call list the same day. So that's just a summary of some of the things that are going on in the office. But I'm here to answer any specific questions you might have.
All right, that's outstanding. Thank you. The last thing you talked about, I think it was key. That's what's resonating with most of the folks, and you explained it in detail enough. I think the average person can understand now what it is and what's its impact. So I thank you for that. I appreciate that very much. We did have one question, and probably another. I'll look at it shortly. Is asked about the process of speedy trial. What does COVID have to do with speedy trial process? That's one of the questions we have here.
Yeah, that's actually a great question. So what happens is when a person is charged with a crime under law, they have a right to have their trial, their day in court within a reasonable time. And that's what's called speedy trial, right? You're not gonna make someone wait for 5 years to go to trial, because what happens? Evidence gets lost, memories fade, things like that. Part and parcel of making a claim and winning a claim for speedy trial is that a person has been actually burdened by the trial. So, you know, first, clearly, if you're in jail pre-trial, then you're burdened, right? You can say, hey, I'm in jail and I'm waiting to have my case heard. That's a burden. For a person out on the street, they might say, hey, I I got a DWI charge. I have a CDL. I'm a commercial driver, and y'all haven't taken me to trial in 3 years. Yet while I'm home, I'm suspended from my job. I'm losing income.
Okay.
And then you have other people, there's case law where people say, hey, look, I've been waiting 2.5, 3 years for my case, but I had to go to a psychiatrist. I can't sleep at night. I have anxiety, things like that. So it's not just enough to say that it was, waiting for a long time, but there has to be some impact. And the courts traditionally have looked at the reasons for the delay, and if it was because of the state. So these COVID delays right now cannot be attributed to the state's attorney's office. It's not like we're holding on to the case. The backlog has occurred because of the, COVID closures. We had months and months where the courthouse wasn't open. But defense attorneys are starting to file those claims saying that, hey, look, we've been open back to full operations since April of 2021. The court has a duty to see that our folks get a trial in a reasonable amount of time. And, the judges, no one has agreed with that yet, but they're listening to the argument. And as we sit here in November, we know 2022 is right around the corner. So for those cases that are in 2019, obviously, I'm encouraging my attorneys to, hey, let's take another look at those and let's get those done. But, we go to a lot of these community meetings. And so people, communities that have been under siege, under crime, they see a lot of repeat offenders. They're asking, why aren't y'all getting more jail time, quite frankly? We're tired of seeing these same repeat offenders. So then that's when we said we got to hold on and wait till a trial date and not make a plea offer. So we're walking a fine balance, to be quite candid, and we got to evaluate every case carefully, particularly when we're making a time served or a no jail plea offer. But at the same time, like I personally have a case of a person was charged in October of 2020, non-violent offense, and they haven't had any trouble at all. And doesn't have a prior record and hasn't been in any trouble since over a year now. We're talking about 13 months. Is this someone that I got to take a look at and say, hey, I want him now to turn himself into jail? He might be out working and contributing and taking care of himself. So we're probably going to do something where, there's some probation involved. But I don't want to disrupt the life if this is the jolt that person needed to, go on the right path.
Yeah. Outstanding. Thank you, sir. Appreciate it.